Yes, sure. The tariffs are a tax, and that's a core power of Congress. But they're a foreign-facing tax, right? And that foreign affairs is a core power of the executive. And I don't think you can dismiss the consequences. I mean, we didn't stay this case, and one thing is quite clear is that the foreign-facing tariffs have in several situations.
Right, and we are.
I'm sorry.
Oh, sorry. I'm sorry.
Were quite effective in achieving particular objectives. So I don't think you can just separate it when you say, well, this is a tax to Congress's power. It implicates very directly the president's foreign affairs power.
Yeah. Mr. Chief Justice, we don't disagree with a large part of that. We think instead of thinking about foreign versus domestic, the better way of thinking about it is Article 1 versus Article 2. And as my friend finally conceded to Justice Gorsuch, there is no Article 2 power here, at least when we're talking about peacetime. We agree with the idea that tariffs have foreign policy implications. Absolutely. Our founders recognize that. That's in the Federalist Papers. But nonetheless, they exclusively committed that power to the Congress in Article 1, Section 8, and gave it as its first power.
A hard day for John Sauer.
Mr. Katyal?
Thank you, Mr. Chief Justice, and may it please the court. Tariffs are taxes. They take dollars from Americans' pockets and deposit them in the U.S. Treasury. Our founders gave that taxing power to Congress alone. Yet here, the president bypassed Congress and imposed one of the largest tax increases in our lifetimes. Many doctrines explain why this is illegal, like the presumption that Congress speaks clearly when it imposes taxes and duties, and the major questions doctrine. But it comes down to common sense. It's simply implausible that in enacting IEEPA, Congress handed the president the power to overhaul the entire tariff system and the American economy in the process, allowing him to set and reset tariffs on any and every product from any and every country at any and all times. And as Justices Gorsuch and Barrett just said, this is a one-way ratchet. We will never get this power back if the government wins this case. What president wouldn't veto legislation to rein this power in and pull out the tariff power? IEEPA is a sanction statute. It's not a tax statute where Congress gave away the store. Congress knows exactly how to delegate its tariff powers every time for 238 years. It's done so explicitly, always with real limits. IEEPA looks nothing like those laws. It uses regulate, which Congress has used hundreds of times, never once to include tariffs, and it lacks the limits of every other tariff statute. And that is why, even though presidents have used IEEPA to impose economic sanctions thousands of times, no president in IEEPA's 50-year lifetime has ever tried to impose tariffs. And the president bypassed statutes that do address tariffs, like Section 122 for large and serious trade deficits, but that imposes a clear guardrail, 15% cap, 150-day limit. This is Youngstown at its lowest ebb. If the government wins, another president could declare a climate emergency and impose huge tariffs without fines or without floors or ceilings, as Justice Gorsuch said. My friend's answer, this administration would declare it a hoax. The next president may not quite say that. This is an open-ended power to junk the tariff laws and is certainly not conveyed by the word regulate. I welcome the court's questions.
Wouldn't your argument also apply to embargoes?
So, and this is the argument in the fine dissent below, and I think there are three answers to that, Justice Thomas. The first is revenue raising. Embargoes stop the shipment. Tariffs start the tax bill. They are first and foremost ways of regulating revenue. As some of your own opinions said, this is the way we actually chiefly got revenue for the first 100 years of our republic. Tariffs are constitutionally special because our founders feared revenue raising, unlike embargoes. You know, there was no Boston embargo party, but there was certainly a Boston Tea Party. The second thing, textually, in the statute, it's different. Regulate appears in a cluster of verbs, as was said before, investigate, block, nullify, and the like. They describe embargo-like controls, prevent and prohibit, for example. But they don't describe revenue exactions. That's Justice Kagan's point. The one verb that's missing here is anything about raising revenue whatsoever. Another point, congressional displacement. Today, there's a whole host of statutes in the tariff architecture of Title 19, which both expressly confer the power to tariff and always impose clear limits. Embargoes by the president, embargoes don't have any of that. They don't set aside that whole thing. If you look at the Learning Resources brief at page 5, it goes through these statutes in detail. Section 122 expressly says duties and then limits it 15%, 150 days. Section 201, any duty on the imported article, but it requires ITC findings. Section 301, impose duties. That's the language of the statute, but all sorts of procedural restrictions. Section 338, the same. I can go through this, and I could start, by the way, Justice Thomas, with the statutes at the founding, all of which expressly said the word tariff or an equivalent.
Let's go back to your non-delegation point. It would seem that if the tariff power cannot be delegated, your argument on non-delegation would also have to apply to embargoes and to quotas.
No, Your Honor, because I think tariffs, because they're uniquely revenue raising, impose special, unique concerns that go back to our founding. And so I don't think that they apply to embargoes. And indeed, the history of this is very, very clear. That, as you just heard my friend say, in 1790, George Washington was delegated massive embargo power from the Congress. But what did Congress not do? And this is why the example cuts the other way. They never gave the president any sort of delegation of tariff authority at the time. Our point is not you can't delegate tariff authority. It's simply that you've got to do so with intelligible principles. And what you just heard my friend say is every single limit in IEPA is one that is not judicially enforceable. There's no limit whatsoever. And indeed, the main limit that was in there, he calls this some compromise position. The only compromise in 1977 was the legislative veto. And as this case comes to the court, that's no longer in the statute at all.
Counsel, yes, sure, the tariffs are a tax, and that's a core power of Congress. But they're a foreign-facing tax, right? And that foreign affairs is a core power of the executive. And I don't think you can dismiss the consequences. I mean, we didn't stay this case, and one thing is quite clear is that the foreign-facing tariffs have in several situations.
Right, and we are.
I'm sorry.
Oh, sorry. I'm sorry.
Were quite effective in achieving a particular objective. So I don't think you can just separate it when you say, well, this is a tax to Congress's power. It implicates very directly the president's foreign affairs power.
Yeah. Mr. Chief Justice, we don't disagree with a large part of that. We think instead of thinking about foreign versus domestic, the better way of thinking about it is Article 1 versus Article 2. And as my friend finally conceded to Justice Gorsuch, there is no Article 2 power here, at least when we're talking about peacetime.
Well, you don't agree with a large part. What's the little part that you do disagree with?
We agree with the idea that tariffs have foreign policy implications. Absolutely. Our founders recognize that. That's in the Federalist Papers. But nonetheless, they exclusively committed that power to the Congress in Article 1, Section 8, and gave it as its first power. So when you hear my friends cite cases like Egan and Garamendi, they just don't apply to this specific unique situation in which Congress is given that power. And if you were tempted by this, I think the best place to look is Youngstown, because what Justice Jackson said, and I was surprised that he quoted pages 652, because what Justice Jackson said is, quote, emergency powers tend to kindle emergencies, so it's essential the public may know the extent and limitations of the powers that can be asserted, and persons affected may be informed from the statute of its rights and duties. And Justice Jackson went on to say there that it's notable our founders didn't give the president revenue-raising power even in a time of war.
Can I just get a clarification of your answer, which is you agree if the word tariff were in the statute, that would be acceptable and constitutionally permissible, correct?
No, it'd be constitutionally permissible. The question would then be, is the open-ended assertion of power here? Because every other tariff
I
statute
get as applied to this case, but the general point is, yes, Congress, you said it's assigned to Congress, but Congress can grant authority to presidents to impose tariffs.
Absolutely.
As a general proposition.
Absolutely.
Okay, so we have to figure out then what regulate importation means. And you've heard my questions. If this statute came out of nowhere in 1977, I think your case would be, obviously stronger. We have to figure out, at least I want to figure out what the Nixon precedent stands for and what Algonquin stands for. On the Nixon precedent, the question is, I think, was Congress aware of that, meaning that when they used regulate importation and it's now being used to encompass tariffs, that's not unheralded because Congress was well aware. You know, President Nixon announced those tariffs in a nationwide primetime speech, 10% across the board in August 1971. It was not some kind of little piece of paper. So it was well known. The question then is, was Congress, why didn't they change the language? Why didn't they say regulate but not tariffs? That's kind of the difficult question from the Nixon precedent that I'll give you an opportunity to answer.
Thank you, Justice Kavanaugh. So 5 answers on the Nixon precedent. First, there is no evidence that Congress thought it was ratifying Yoshida. It was a single court of appeals case.
It's not somewhat my question. I never mentioned Yoshida. It's the use by the president of that power under regulated importation.
If we're just talking about that, President Nixon did not rely on the statute whatsoever. I mean, that's very clear. In fact, we have a Marshall McLuhan moment here because you have before you Alan Wolf, the person who was there in the room with Nixon, saying Nixon totally disagreed that this statute applied. So if we're just talking about Nixon, I don't think it can get the government where it
Go to your
wants
other
to go.
four. Other four.
So I think the only way it does any work is if the president is through the vehicle of Yoshida, and that's what I take it the government is arguing. And with respect to that, this cert-denied intermediate court of appeals decision, I don't think can come close to overcoming the clear, plain text. The word regulate is words regulate importation. The word regulate has never been used. The Congress uses the term 1,499 times. We got about that number of hits when we looked at it. And maybe there's some double counting, but it is never used even once to impose taxes or revenue raising. And that was the question that Justice Barrett was asking. And so I don't think that this intermediate court of appeals decision will get you there. And then even if you thought that Congress knew about Yoshida, and even if you thought they liked it, which there's absolutely zero evidence of, I don't think that helps the government for reasons that Justice Alito was pointing to, because Yoshida said 3 things. A, TWIA doesn't give the unlimited authority that the government is seeking here. B, they were only upholding the limited specific assertion of authority that President Nixon sought there. And third, going forward, the solution, they said in footnote 33, was to use Section 122 of the 1974 Trade Act, 15%, 150 days. So we have no problem with the president doing that. It's just that this president has torn up the entire tariff architecture. You know, for example, he's tariffing Switzerland, one of our allies, which we have a trade surplus, 39%. That is just not something that any president has ever had the power to do in our history. And the idea that Congress, by implication, did this in 1977 and handed him all this power, I think is really difficult.
Just to ask the other. Go ahead.
Justice.
Let's start with just the bare statutory language. You have arguments about structure, you have arguments about history. There are strong arguments, but let's just start with the bare statutory language, regulate importation. If we disregard all of the rest, would you dispute that that would include the imposition of a fee?
So if it's revenue, yeah, we do dispute that, absolutely.
What if there were a statute that said, I mean, suppose that there's a particular national park that's very crowded, and Congress passes a statute that says the National Park Service may regulate admission to the park. Would you say, well, that does not allow them to impose a fee?
So, you know, Your Honor, sometimes we think of fees as not revenue raising, but rather capturing the cost of government services. In your example, the going to the park, that may, you know, those kinds of cases, which I think
suppose it goes beyond the cost of running the park. Congress just wants to control admission to the park, regulate admission. Wouldn't that include the imposition of a fee?
So if it doesn't raise revenue, then, and it's not about that, then I think that's fine. If it does,
it raises revenue. That's
then I think it's a
that's
tougher
the hypothetical. That wouldn't apply.
So I think in that circumstance that it wouldn't be a regulation in context. It wouldn't be permitted. That is, at least in the context of tariffs and trade, we know, Justice Alito.
Okay, well, that gets into your other arguments. We start out with the bare statutory language, and that was what my question was about. Do you think all tariffs are revenue raising? Suppose that instead of imposing these across-the-board tariffs. Suppose that an executive order imposed a tariff on one particular country and provided that this would take effect in 90 days. And suppose that within those 90 days, an agreement is reached with that country so that no tariff is ever collected. Would that be a revenue-raising tariff?
I take it the initial point and on its face, it is revenue raising, that's what it's for. And so I think that would. And look, I don't doubt that there are edge cases. That is what this court's confronted just recently in FCC versus Consumer Research. And you said, look, what is a tax is sometimes very hard. What is revenue raising? This is obviously revenue raising. Their own brief to the court says it's going to raise $4 trillion. And Justice Alito, you in your Consumers Research dissent, or Justice Gorsuch's dissent that you joined, said taxation is special and different. And it is the most powerful thing the government does. And the idea that Congress, when they know exactly how to write tariff and tax statutes, gave this power by implication through the word regulate, I think is very, very hard.
Well, you cite many different statutory provisions that impose tariffs. And you have a point if that's the relevant universe. What if the relevant universe is tariffs that are imposed in emergency situations?
Yes, so I think it cuts the other way. So, you know, as Justice Jackson said, it's when you're in an emergency situation, the statutes actually have to speak with more precision. The public needs to know because emergencies beget emergencies. And I would say the best way of understanding what Congress does in emergencies is to look at their emergency statutes. Not one has ever given the president a taxation power or a tariff power. We've had all sorts of emergencies for 238 years. No president has ever said, oh, the way to deal with that is I need to have a tariff authority. And as Justice Sotomayor said, IEPA gives already a quota power, so you can get what the foreign policy piece of it is through that. I'd also say, Justice Alito, Dames and Moore, which the Chief Justice referred to earlier, I think is really important here because the Solicitor General in that case made a similar argument to what you just heard on the claims provisions. He said it falls within regulate. Regulate is a capacious term. He said, Justice Alito, what you said, this is an emergency situation. And he said you've got to defer to the president on a major issue of national security about this very statute. And what did the court do? It rejected those arguments and said IEPA doesn't cover this.
You say that this is not, this case does not, these executive orders do not address an unusual and extraordinary threat. I understand that argument. Suppose that the facts were that it was suppose that there was an imminent threat of war, not a declared war, but an imminent threat of war with a very powerful enemy whose economy was heavily dependent on U.S. trade. Could a president under this provision impose a tariff as a way of trying to stave off that war? Or would you say no, the president lacks that power?
Couldn't do tariff, but could do quota, embargo, all of those things.
Could do all those things, but the president could not impose a tariff.
There's
That's one thing he couldn't do.
There's a category shift between a tariff and the other 8 powers in IEPA because it is revenue raising. So it's not a difference in degree or something like that. That's why, you know, I don't doubt tomorrow.
Even if the purpose of this had nothing whatsoever to do with raising 1 penny. The president didn't want to raise 1 penny. The president wanted to deter aggression that would bring the United States into a war. You would say, no, can't do that.
Yeah, Justice Alito, I think you've said many times the purpose isn't what you look at. You look to actually what the government is doing. And if you disagree, if you think we're, you know, if you think, or excuse me, if you ruled for us and the president says, I need this power, he can go across the street to Congress tomorrow and get it by a simple majority through reconciliation. But if you vote for them, this power, as Justice Gorsuch said, as Justice Barrett said, is going to be stuck with us forever. The power to jump.
Can I ask you?